Good morning, everyone. Welcome to the Thursday, May 29th, 2029 agenda meeting of the Minnesota Public Utilities Commission. My name's Katie Sieben. I chair the commission. All commissioners are appearing in green for those of you online yet again today. Apologies, we do know our camera is not fully in the right color, but supposedly everybody can hear online, so that is all good. We have two items up today. Our first item will be introduced by Kit Gomez. Mr. Gomez, welcome, and please introduce item number 1 when you're ready.
Good morning, Chair Sieben and Commissioners. Item number 1 is docket number E229-119/SA-25-134. involving Detroit Lakes Public Utilities and Lake Region Electric Cooperative in the matter of the joint request of Detroit Lakes Public Utilities and Lake Region Electric Cooperative to modify electric service territory boundaries. The question before the Commission is, should the Commission approve the joint request of service area transfer from Lake Region Electric Cooperative to Detroit Lakes Public Utilities and request MNGO update the service territory map? We have representatives from the Department of Commerce, the Detroit Lakes, and Lake Region available for questions. Staff has no additional comments.
Thank you very much, Mr. Gomez. Commissioner Tuma, did you want to begin with questions or
Madam Chair, it was done very well by the applicants. Their counsel put it together as expected, so I have no questions. I did wonder, as I was looking through it, how Detroit Lakes got its name, because I'm not a big fan of Detroit. They're kind of like in the wrong league, and but
That's where Commissioner Hom is today, actually.
Is he?
Oh, I forgot to take the roll. My apologies, Commissioners.
Yeah.
We're all a mess here. Okay, so we're gonna just
Take a roll.
pause that thought or history lesson on Detroit Lakes. Let's take the roll today, please. Apologies. Commissioner Partridge.
Here.
Commissioner Sullivan.
Present.
Commissioner Tuma.
I'm here.
So a quorum is present, and back to Detroit Lakes.
But Detroit Lakes was actually named by a French missionary, and Detroit is actually a French word. I didn't know this.
Straits.
It means straits. There you go. You win the prize. There was actually a sandbar that drove out into Detroit Lakes for years, and that was what they called the straits. The Ojibwe called it the lake in which there is a crossing on a sandy place. And so Detroit Lakes actually gets its name from French missionaries, not from the Detroit city we know. So, Madam Chair, I would move the decision option. Yep, I move the decision option to approve the joint request for the agreed upon permanent boundary change for Lake Region and Detroit Lakes Public Utilities and request MNGO update their maps.
Is there any discussion of Commissioner Tuma's motion? Hearing none, all in favor, please say aye.
Aye.
Aye. Opposed? The motion prevails. Thank you very much to all the participants for the first agenda item. Our next agenda item will be introduced by Ms. Marcus in just a minute. Ms. Marcus, when you're ready, please introduce item number 2.
Good morning, Chair and Commissioners. Item number 2 involves CenterPoint Energy Resources Corp. Doing business as CenterPoint Energy Minnesota Gas in docket G008 GR 23173 in the matter of the petition by CenterPoint Energy Minnesota Gas for authority to increase natural gas rates in Minnesota. Also docket G008 MR 23174 in the matter of CenterPoint Energy Minnesota Gas's filing to establish a new base cost of gas filing, PGA 0 out for interim rates in CenterPoint Energy's general rate filing, docket number G008 GR 23173. The question before the commission is, should the commission accept the offer of settlement and adopt the administrative law judge's findings of fact, conclusion of law, and recommendation to approve the settlement? Staff and parties are available for questions.
Thank you, Ms. Marcus. If the parties would please come forward, we'll begin with appearances. Starting on my far left, Mr. Sutton.
Chair Stephen, Charles Sutton here on behalf of the 49ers and LiUNA who jointly intervened.
Good morning, Chair, Commissioners. Jason Luce on behalf of CenterPoint Energy.
Good morning, Madam Chair, Commissioners. Eric Swanson with Winthrop and Weinstein on behalf of CenterPoint Energy, and also online we have Ann Bulkley.
Good morning, Madam Chair and Commissioners. Peter Schultz with the Office of the Attorney General, Residential Utilities Division.
Good morning, Commissioners. Brian Edstrom with the Citizens Utility Board of Minnesota.
Good morning, Chair Sieben. Richard Dornfeld, Assistant Attorney General, appearing today on behalf of the Minnesota Department of Commerce.
Great. Welcome, everyone. Sorry, I just got note that there's also a late filed decision option from Commissioner Tuma that didn't get announced, but we have it in our, commissioners have it in your packets, but just making sure that we noted that. So why don't we begin? We don't have opening statements, but it would be helpful to hear from CenterPoint about an overall statement of the case or why what you're proposing the commission do today. Mr. Swanson, if you're ready.
Remember to turn my microphone on for those online. We're very happy to be here today to discuss the all parties, all issues settlement. I want to thank the parties for working hard to get to this result that we think is a fair resolution of all of the issues. Want to thank Judge O'Reilly for her review and staff for the briefing papers. We do think it's a solid overall package. As you may recall from the interim rate discussion, in part because of the ability to resolve all of the issues, including revenue apportionment for 2025, we were actually able to see a slight rate reduction for residential customers from what had been in place. We think it's an overall very sound package, and we just look forward to answering any questions you have on any of the specific issues.
Okay, thank you very much, Mr. Swanson. Commissioners, do you want to begin by moving through different segments of the docket, or we can begin just wherever you want with questions? I didn't have a really set plan here. Commissioner Sullivan?
Yeah, I just have just two quick clarifying questions, and I don't have. I first of all just want to state I appreciate the settlement. I've reviewed the record, and I'm very comfortable with the settlement and comfortable with what the parties have worked on and what the company has agreed to, as well as all the parties. So I appreciate that. I think that my sense is that you've all struck the right balance and that we'll have a package that delivers just and reasonable rates, and I'm appreciative of that. So I'm comfortable after we get through it, moving, making a motion, and I'll be ready to do that quickly. But I do have some quick clarifying questions. I just, on page 9 of the briefing papers, there's the discussion, there's the question there, regarding the property tax, and then on page, I think it's 17 or 19, it's the STI true-ups, and I just wanted to make sure that if the company could just speak to those. There was just a little bit of a question in the briefing papers as to, And if anybody else wants to weigh in on that, I just want to clarify that for the record.
Mr. Swanson.
Yeah, the company agrees with the compliance filings on both issues.
Okay. And
And we would propose to do them together.
propose to do them together? Okay. And I'm looking at staff, that seems to be, do any of the parties want to weigh in on that? Are you comfortable with that?
What is the question, Commissioner Sullivan?
Just if how the true-up is going to work.
With the refund?
And that the company would then do compliance filings to lay it all out clearly for you.
Chair Sieben, Commissioner Sullivan, the short-term incentive pay true-up is an ongoing requirement from prior rate case decisions. This settlement doesn't expressly address that, but given that the commission has previously ordered it, the department's understanding and position is that that requirement continues. Regarding the property tax tracker, the company does or proposed true-up. The company currently uses a tracker, and that difference gets reconciled each rate case. The department is comfortable with that approach. I think it's more consistent with the regulatory construct. We understand that the company is proposing to make a compliance filing showing the balance of that tracker, not to create a new property tax true-up that would be done on an annual basis. I just wanted to confirm that was your understanding. That's how the department understood it.
I just want to make sure it's clear how it's all going to mechanically work. So, does anybody else want to? We're good. Okay, those are my only questions. Otherwise, after people are ready, I'm happy to make a motion or let somebody else make one. But that's where I'm at.
Commissioner Tuma. Oh, Commissioner Partridge.
Thank you. I have a handful of questions. I too want to thank all the parties for working hard to get to an agreement and a settlement, and I think that the settlement seems like a good landing place. So, but I do have several questions that came up as I reviewed the record that I wanted to raise since you all traveled here. I'll make it worth your time. All right, I want to first talk about the standby peaking service. So it appeared to me that this was an existing tariff and an existing offering, and the company proposed to update it with an increased customer cost, but then the settlement kind of reversed that proposal or didn't accept that proposal. And let me get to the right page. Here we go. Okay. And so my question for you all is, first of all, did you all watch the planning meeting on Tuesday? I did not see CenterPoint here. I did see the OAG, and I did see Fresh Energy and Cub. We didn't have any utilities, but I hope you were watching online. Okay, great. Got confirmation. So I just wanted to say that we discussed this issue quite a bit, and there were experts here from E3 who talked about some of the strategies and approaches that different utilities are taking across the country regarding dual fuel customers who need gas as their backup fuel and use it during, winter peaking. And I hope that you'll continue to work with stakeholders and perhaps even the experts that we had here on Tuesday to talk about kind of the pros and cons of the approach you have here and some of the alternative approaches elsewhere, specifically in Canada, with Energier and what is it? It's a hydroelectric company. I can't remember which one, but Quebec. Thank you. Thank you, Ms. Supas, for saving me. So raising the customer charge is one way to ensure that you're recovering fixed costs on customers who are using lower volumes but need that peaking service. But as we talked about, that can have unintended negative consequences. And so I am not going to amend your settlement here for this particular issue, but I do hope that you'll continue to work on that and to think about alternatives and perhaps evaluate alternatives. One of the possible unintended consequences of increasing a customer charge is that the customers choose to leave the system. And I know that you all probably don't want to incentivize that, and it could have some pretty serious impacts on the electric system if that happened, at scale. So I hope you'll work with electric utilities and work with other stakeholders to evaluate how this particular program is working that you've proposed and think about alternatives. I also wanted to know if someone can explain to me how you identify and or recruit customers for this rate.
Mr. Swanson.
Thank you, Madam Chair, and Commissioner Partridge. I'm informed that currently we have no customers on the service, but it would be the key account managers who are working with our customers to explore whether this is a rate that they would be considering.
Okay. My understanding is that residential customers are eligible for this rate, so I am curious how this integrates with your eco plan, because the key account managers typically don't work with residential customers.
Thank you, Madam Chair and Commissioner. Sorry, I have to slide back and get some coaching on this, but it's my understanding from the brief discussion that is something that the company isn't really currently pushing, but it's certainly something that the company is willing to explore.
I mean, it says that you're offering it to residential customers. Is that incorrect? Because you proposed updating the residential customer charge to $13.09 a month.
Madam Chair, Commissioner Partridge, that is correct, but we aren't aware of any ongoing marketing efforts right now.
Okay. Okay, well, I hope, Mr. Dornfeld, maybe you can flag this for your colleagues in the eco side of things, that this would be really helpful to continue to follow and understand how customers receive this type of offering and whether it's something people are adapting or not.
Along this line, Commissioner Partridge, and I'm glad you brought up the planning meeting, that discussion. One of the things that's not in our suite of decision options, which will eventually be when we have a conversation later about other issues, is requests for information to be filed in their next rate case.
Yeah.
And I would be very open to a decision option here to require that. So I'm not questioning Mr. Dornfield not do it, but sometimes memorializing it in the order for the next rate case. So if it's something you're interested in, when we have a break or something, maybe we could spin up a quick decision option. I would support it 100%.
Excellent. I would like that.
Guys, I just want a clarifying question to Commissioner Partridge so I can understand where she's at. I thought that the E3 presentation, and I picked up on this in the settlement as well, and I looked at this and I thought, well, this is actually directionally going along the lines of where E3 was, some of the research was indicating. So I'm worried that maybe I misunderstood something, but I thought that they were actually, so that the utility can recover their fixed costs, and a possible strategy is increasing that fixed charge. And I think the settlement adopts going from $4.50 or $5 up to $13. So I felt like it was directionally in that line, but maybe I missed something
Right. So, yeah, I think you're right. I did misstate that the department pushed back on it, but that it was adopted through the settlement. I think E3 mentioned that that is one thing people are doing, but noted that there were lots of unintended negative consequences associated with the strategy, and then presented what they've found was a more attractive alternative, which were utility to utility coordination and payments for capacity on the utility side.
hydro-connect model.
Yeah,
Yeah.
so that it's not put on the customer. It's more on the utility side to coordinate those payments and value the capacity that is avoided on the electric system. So,
And I'll just say, like, I'm glad you raised this point because I was very interested in it, and in the next rate case, I would be very interested in having CenterPoint explore that more, because I think that's a very interesting model. So I just
yeah,
doubling down on what you just said.
great. I guess we can ask parties if they object to that, if anyone would defect from the settlement if we ask for reporting in the next rate case on this matter.
Madam Chair, Commissioner Partridge, we just need to see the language, but no, I can't imagine that it will be a concern.
Okay. My next question is around decoupling, and can I keep going? Okay. My next question is around decoupling. I want to thank the department, specifically Mr. Bond, had really good testimony on this matter, so thank you for that. And he rightfully, I think, identified an issue with the way it was being calculated based on a per customer approach as opposed to total sales approach. But I have a broader question about the role of decoupling for our current trends that we're seeing in gas consumption. So when I used to work at CenterPoint, for those who don't know, many, many years ago, and the way I was taught to understand decoupling is the idea is that with efficiency, the gas utility will see declining sales, and therefore we need some sort of true-up factor to remove the disincentive for efficiency and ensure that the company is able to recover the costs of service under a declining sales trend. Yet, we haven't really seen declining sales, and I think that the decoupling mechanism has been in place for well over a decade now. I'm wondering if the department and/or the utility, maybe both, could explain to me, maybe I'm misunderstanding this, but what is the decoupling mechanism doing as we watch sales continue to go up? Mr. Dornfeld, do you want to weigh in on that?
Chair Sieben, Commissioner Partridge, I think that you have accurately recited sort of the theoretical benefits of decoupling to the extent that the commission wants to kind of reevaluate whether that policy is effective. Certainly, I'm sure the department would be happy to dig into that in a rate case or a commission investigation and kind of look at that across the industry. Because certainly if a program isn't achieving the desired outcome, then it makes sense to look at it again.
Thank you, Mr. Dornfeld. Mr. Swanson?
Yeah, Madam Chair, Commissioner Partridge, the observation I'd have is that I do think the decoupling mechanism is still makes sense on a policy basis to remove the disincentive to encourage the company. Whether the results are what you or the company or others are hoping for is a secondary question, but I do think it serves that important function of taking away that disincentive to be pushing conservation.
Can you maybe speak to why we're seeing increasing sales at the same time we're seeing such high achievements, at least reported through the ECO program?
Madam Chair, Commissioner Partridge, I don't know that we built anything in this record around that. So I would be speculating, I think others would be speculating without digging into it more. Obviously, sales are affected by any number of things, including the housing stock, other things. But I don't think we have anything in this record for you on that.
Okay. And Mr. Dornfeld, for the department, maybe you have someone online who could speak to the energy savings that we're seeing in ECO really not being reflected in the trends we're seeing in sales?
Unfortunately, Mr. Bond, I believe is on vacation, is unavailable
Okay.
to get into that. So I don't think we have anyone. Yeah, I don't think we have anyone available today who could really get into the details for you.
Okay, and that's fine for today. I know that the company will file the decoupling evaluation report in September, and so maybe we can dig into that a little bit more to look at why these things aren't, at least at face value, lining up as we would expect. And I will say, I'm not here opposing decoupling. I think that theoretically it makes a lot of sense, but it appears to me that it's functioning almost like a multi-year rate plan true-up factor and not as it was initially intended. And I also think just more broadly, and this is not just CenterPoint specific, it is worthwhile to understand and kind of track what we're seeing on the eco side and what we're seeing on sales and consumption more broadly to understand the role of eco within that paradigm and ensure that everything is moving in the direction we want it to. There may be reasons why those two aren't aligned, but I think we need to dig in and understand. My next question is about economic curtailment. So I just had a quick question on, and this is, my apologies for not knowing the answer to this, but wondering if you all will be reporting on the achievements of that program, the uptake of that program in the 21-135 docket or another place, just so we can kind of see how successful that program is and what value it's providing.
Madam Chair, Commissioner Partridge, we will include that in the reporting in the 135 docket.
Awesome. Wonderful. I have one final question, if it's okay. Thank you. Okay, on the legacy plastic replacement, I know that you have in the settlement agreed with SRA's request that you provide an update on whether and how feasible it would be for you to kind of speed up or ramp up replacement of the Tier 1 legacy plastic lines. I want to just say I really support that they're wanting you to move a little faster on that there's still quite a bit of miles of this plastic. I personally had the opportunity to see some of those old plastics in your lab, actually, CenterPoint, and I too would like to see that move a little faster. And so I hope that you'll work really hard to see what you can do to get the remaining 300 miles of the Tier 1 legacy plastic out of the ground and replaced with something that is more durable and safer.
Thank you, Commissioner. We appreciate that.
I have some questions too, but
I'll find a way to more compliant stuff. So.
For CenterPoint first, I saw that you agreed to take out your gas resource planning costs from the settlement, and I assume it's because you're still planning for it and using it in a different way, but anything to add on that topic?
Madam Chair, Commission, I can answer that. It was just based on the timing. At the time we initially put it in, we weren't sure when our filing was going to be, but
You weren't sure when?
when our initial filing would be. So it was pushed out further than we initially thought it might be. So we wanted to. So so the cost will be probably included in the next rate case.
Okay, so they're still coming? They're
Yes, yes.
They haven't been suspended in any, or the efforts are still underway. Same with some of the expenses from NGIA were removed in the settlement. This is the type of thing where it's like, how do you talk about the settlement without a lot of understanding the back and forth that happened? But can you please help give the commission an overall understanding of the approved projects that we are excited that the company is undertaking in NGIA, and then how you landed at a point of removing some of those costs, just For your context, I just read the settlement document, not into the testimony about it.
Chair and Commissioner, the number we took out was the number we proposed to take out, and it's based on actuals. So the ramp up to NGIA, again, when we were developing this rate case quite a while ago, we weren't sure on the timing of everything. So at the time we had put in the initial numbers, we envisioned NGIA possibly ramping a bit earlier. I wouldn't say it went later than we thought, but we wanted to ensure that we had some flexibility there. And during settlement, we did discover that it was going to take a little bit longer to launch some of these programs, so the costs are going to be pushed out a few longer than we initially envisioned.
So the costs that are included in the settlement are part of the 2025 year, is that correct?
Correct.
And then the amount that was reduced, was that for 2025? And what I think I heard you say is the projections when you filed ended up being not as quite as high as you needed to, and that's why the amounts are lower in the settlement?
Madam Chair, that's correct.
Okay, that seems to make sense, or that makes sense. And for the department, is there anything, I assume that, since you were the one, or no, I apologize, it was the OAG that was trying to get some of the costs removed, it looked like. Is there anything else you wanted to add, or you're fine with, obviously, with the way it settled here on NGIA?
Thank you, Madam Chair. Yeah, what CenterPoint said is accurate. It's a timing issue. Our direct testimony recommended that they make an adjustment to sort of match the Commission's final order on the NGIA plan, and so how that affected the timing. So that's what they ultimately did. And I believe that there's also a rider for NGIA costs. So this is really just about setting a baseline, and actual costs will flow through the rider, I believe.
Yeah, that's what I was going to confirm too. Or I think I asked in my briefing. There is the NGIA rider, so a portion will be in the rate case here, and then is it the later years will be in, or a portion of 25 will go into a rider too?
Yeah, Madam Chair, that's correct. It will be trued up in the rider. So
For 25. Okay. And then from there on, it will go through the rider.
Madam Chair, that's correct.
Okay. For the OAG, again, or the department on executive compensation, I appreciate the discussion and the look into this and the settlement on this topic. And it seems like you arrived at what appears to be like a very reasonable levels here. Anything that you wanted to add? I know Cub also weighed in on this. Anything, maybe Cub, Mr. Edstrom, to ask you a question. Can you just say why the executive compensation settlement results in a good outcome for the public?
Thank you, Madam Chair. Yeah, I think limiting rate recovery for executive compensation appropriately reflects that utilities executives are involved in more in managing a company than just the ratepayer service. So we were pleased that CenterPoint was willing to compromise on that issue, and we think having the cap set forth in the settlement agreement is appropriate in protecting ratepayers from paying more than appropriate for that compensation.
To turn to the issue of workers, Mr. Sutton, thank you for being a part of the settlement and representing IUOE. I will also point out that this may be your last docket appearing as a labor representative on behalf of the unions that you represent. And so on behalf of the commission, first, we thank you for your involvement here over the years and your great advocacy on behalf of working people of Minnesota. We're going to miss you. So thank you for being here. And can you just give brief comments on why the IUOE was supportive of the settlement and why you think overall it's in workers' interest for the commission to approve the rate increase here today?
Yeah. First of all, Chair, yes. Well, first, thank you for the kind words. I really appreciated all the opportunities to advocate here on behalf of workers. I'm here today on behalf of IUOE, and we jointly intervened with LAUNA. So, on behalf of both of us, we support the settlement. As we've always said, our members pay rates, and they also work on the projects that ultimately need to be funded through rates. And so we understand both perspectives. We feel like this settlement is fair. Candidly, we intervened originally because there had been a number of issues that were a little more directly tied to our work that had been raised in past rate cases. And so if those were going to be raised, we wanted to be part of the discussion. None of those issues really got raised in the present case. So as a result, we were just interested in seeing a fair settlement. And that's what we saw come out of the process, and so we were happy to sign on.
Great, thank you. And to the company, in the record, there was a letter filed and a subsequent letter filed from the Gas Workers Union. And I understand that you came, even though they weren't a formal party, you came to some sort of agreement with the workers on that issue. Is there anything you can tell the public or the commission further that would be helpful and just help assure us that your workers are supportive of the issue that's before us here?
Madam Chair and Commission, thank you for the question. Yeah, CenterPoint greatly appreciates our union labor and works hand in hand with union. That issue was resolved through the collective bargaining process, which is we felt that was a fair and appropriate resolution, and the matters, and as the union noted in their subsequent letter, that matter is now behind us.
Is it dropped? I know it's not a matter in our docket here, but is the court case dropped too as well?
So Madam Chair, I don't know if it's officially been, but it's our intention to. So it's been dropped from our purposes. Yes.
Okay, for the Minnesota workers,
Correct.
Especially.
Yeah, and just to clarify, I'm just not entirely sure if the paperwork's been filed, if the judges signed off on it. But
Okay, I think it is just an interesting and insightful matter for the commission to be notified by a union that we don't traditionally hear from, where they had concerns about the compensation that their workers were paid. So I'm glad that it was resolved and appreciate the company working on it, because we all collectively care about your workers, as do you, I know. So it's a good outcome, it seems. Commissioner Partridge.
Thank you so much. I did want to speak to that as well, and thank you for bringing it up, Chair Sieben. I will say that it was not good news to hear that your workers felt that you were discriminating against them, and that in arbitration it was found that you were in fact discriminating against them. That was pretty upsetting, I think, as a commissioner, to see that, as a Minnesotan, to see that CenterPoint Energy, our largest gas utility, who receives a lot of support from labor here at the commission and at the legislature, was treating Minnesota workers that way. So I appreciate the gas workers for bringing that to our attention. I think we were all very concerned to see that, and I hope never to see that again, if that makes any sense. And I think when we hear from your workers that they are feeling that you're not supporting them, that they are the frontline folks who were facing not only the hazards of their job normally, but also the hazards of working through the pandemic, and not being valued for that work like their non-union counterparts were, particularly in other states, is both disheartening and not divorced from the complaints that we see about executive comp. And so I can't fix the corporate structure for the United States of America today, but I think this is certainly an illustration of that imbalance and the frustration that people who are not in the executive suite feel when they see the executives making millions and millions of dollars and workers, particularly union workers, missing out on basic incentives for hazard pay. So I just can't highlight enough how frustrating that was to see. I'm also really happy that you were able to resolve that. I hope that the gas union workers all feel valued by the company going forward and do appreciate dropping that lawsuit. I hope, again, not to see you sue your workers after they win a fair arbitration award. So thank you.
Thank you, Madam Chair. Ditto, by the way. Mr. Swanson, I got two things. One good. One, I don't want to say bad, but a little more challenging. So would you want to start off with a little more challenging or the good?
Well, Madam Chair, Commissioner Zuma, let's do the challenging one first.
If you could, Paula, I'm going to pass along the value line. We're going to have a chat about capital structure a little bit, about equity to debt ratio. It is something we have had conversations on a while. I was thinking about it. I think we're probably the constant here, Mr. Swanson, from when we first started having this conversation back in 2016, when Clark Camel, talk about bringing back names from the past, got me all wound up on this, okay? And so before I get to 2015, I want to take us back, and I want to, ground ourselves a little bit to 2003. In April of 2003, this commission closed up an investigation of Reliant, which in the process of that investigation became CenterPoint. And as you recall, that was at the time of the energy merger craze, and it was imploding on people, and commissions were getting nervous as they saw the acquisition of Minigasco by CenterPoint about the viability of that company. And the major discussion, or one of the big discussions in that 2003 order, was around capital structure, and it's the ratio between debt and equity. Too much equity can be a bad thing, and too much debt can be a bad thing. And so we've always kind of focused on a 50-50 kind of breakdown as kind of the standard. It's not, it has to be, okay? But we said back then we're going to be watching you, and so we have watched, and then to keep an eye, because your debt to capital or debt to equity ratio at that time in that crisis was looking kind of too high debt and looking a little, causing people nervous. And the reason we get nervous is because debt people are going to want their money. They can force you into bankruptcy and cause big problems for service and ability to do projects to keep those plastic pipes keeping replaced. Okay, equity people can run with this, and they recognize that they're stuck with you, and so they'll kind of ride the ups and downs. But that's why we pay them a little bit more than what debt is, and so there's that balance. And so we were a little bit too heavy on the debt, and there was some concern. So comes 2015, you were asking for your fictitious, okay, capital structure, okay, to be increased from 50, I think it was 51% at the time, up to 52.5, okay, and Mr. Schultz, the OAG, was the person who pushed back on that and said, wait a minute, totally litigated case, isolated issue. We said, look, folks, you haven't been performing well, and so what you're looking at is the value line. And if you see there where the yellow is, that's the kind of what I remember seeing in the last rate case. But if you go back all the way to the beginning of that row, you see that the debt to equity ratio was 30-70 essentially, okay? And so back then we're saying, wait a minute, There's a big gap between what we are fictitiously paying under the Minnesota settlement. We want you to stay at 50/50, and so we've locked you in at 50/50. And so the OAG pushed back and said, let's go to 50/50. And that's what the commission, if I recollect, we went to as a 50/50 debt to equity ratio in 2000, and the 2015 rate case was 2016. Is that your recollection?
Madam Chair, Commissioner Tuma, yes.
And then with the next two rate cases, if you follow it up into that, towards that yellow on there, I remember feeling a little bit more comfortable. Mr. Camel and our staff, Mr. Camel had left by that time, but was feeling a little more comfortable. There was a trend going on through there that looked rather positive. And so by the last rate case, we were seeing projections, Madam Chair.
Sorry to interrupt, but Paula, could you possibly put it online? Or could, because we don't have a copy, does anyone online, someone online just has no idea what we're talking about, including Ms. Bulkley? Or,
Well, I need mine. There should be one up.
I mean, somebody should just hold it up, it's easy to see.
Yeah, it's the big print, yeah.
I got my glasses.
Well,
I'm working off the, so that everybody knows, it's the March 7th, 2025 value line analysis from Emma Jules, I think. It's what we've kind of been monitoring. This is what we've used in past rate cases just to keep truth test. And so I was pointing that when in 2022, 2021, kind of when we were doing the last rate case, things were looking up, okay? And so we allowed you to have a higher fictitious rate of return on your equity. So it went up to 51. I can't remember, what was the last rate case we had you at?
Madam Chair, Commissioner Tuma, I don't have it up, but in front of me now, I could find it fairly quickly. But the last two rate cases were something where 51 and maybe 51.7, something like, in that ballpark.
And I'm not going to question the settlement because there's things that, you know, obviously you guys trade off. Obviously, the company wanted to see it go up. And so in this rate case, you've now agreed to essentially 52.5 or right thereabouts.
Madam Chair, Commissioner Tuma, I'd take issue a little bit with that because knowing the issue would be front and center in your mind, at least, if not others, what the parties agreed to was just an overall weighted average cost of capital. So
That's right. And
the settlement didn't specify an equity ratio in this case.
That's a good question. Our staff backed it out. Do you disagree with the staff's backing out? I think it's on page
Madam Chair, Commissioner Tuma, we don't
36 of the briefing page.
We don't disagree with the math if you assumed a 52.5% equity ratio, but the parties didn't agree to a 52.5% equity ratio. So if you instead assumed, say, a 51, then the implied ROE would be higher.
Right. And that's the point. I mean, it affects the ROE. So even though Ms. Bulkley, who always does a great job, Ms. Bulkley, my understanding, I'm always kind of hard on you on this world. I'm very comfortable with the ROE that was determined, but the point being is that because you're getting 52.5, there is a bump that ratepayers are paying a little bit more than they would otherwise and would stay at 50-50.
Again, Madam Chair, Commissioner Tuma, I actually disagree with that. If the parties had agreed to a 50% equity ratio, we would not have agreed to a 7.07 overall weighted average cost of capital. We wouldn't have reached a settlement.
Right. And that's the point I'm trying to make, is that it was built in there. The company wanted to see that higher equity number, and that's fine. That's things get worked out, and I'm comfortable with that. If it were isolated and it were in a litigated rate case, and this came in front of us, given where then, and this is where it starts getting kind of shocking to me, because it went from 37 in 2022 and it's dropped now down to 34.5. This, of course, according to value line, I don't know how accurate it is, but that would have gave me some heartburn, and I would have asked a whole lot of questions if this was a litigated rate case on that question of whether going to 52.5 was adequate. But I'm not going to relitigate it. I'm just saying that would have caused me some heartburn. And I think the thing that caused me, what confused me, and I want to get this clear in my mind, is highlighted below, you'll see in red, is Louisiana, Mississippi. Okay, so when we started this rate case, there was concern because CenterPoint had put a for sale sign outside their corporate offices and said, we're selling things. And there was some worry, are you going to be selling Minnesota? And you assured us at the initial rate case starting, nope, Minnesota's not for sale. We're selling other assets in the south, and here it is now, Louisiana, Mississippi, which is supposed to close in the first quarter of this year, okay? And the result of which then would, I think, mean more dollars to do projects so that you don't have to do debt. You could pay down debt, which should then start improving your debt to equity ratio. And so, and you look at it, at least Emma Jules here is thinking that must be the case, because if you start looking into the future, out 4 years, she's saying your debt to equity ratio should be about 41. I'll be honest with you, when I started hearing the sales talks, I was starting thinking we're going to be at 41 when we get to this point where we're sitting right now. So I guess that was my shocker walking into this rate case, looking at the debt to equity situation and where we're at, that we're not there now. But the sale said it hadn't gone through as of March 7th. So I'm just trying to find out, has that sale gone through? And it is a corporate policy to start getting that debt to equity ratio closer to what's in that last column there, 5941, which is the projected, again, that's, value lines projection. So what do you say? What's going on?
Madam Chair, Commissioner Tuma, the sale has closed. Again, so just to be clear, and I know you're aware of, but for folks listening to the debate too, what we're talking about here is CenterPoint Energy Inc.'s capital structure on value line as opposed to CenterPoint Energy Minnesota Gas. And they are different, and you see the impacts of it. For example, when we file our Schedule Ds in the initial filing of the rate case, we lay out what the debt to equity ratio is for CenterPoint Energy Inc., but then you also see a significantly higher implied ROE. 15% in this case was what we used for the implied ROE for CenterPoint, for CenterPoint Energy Inc., in part because of the debt to equity ratio. But yeah, I think your observation of the trend being shown here is accurate. As far as what the future may hold for the company.
And go ahead if you want to add a question there. I'm going to talk to Mr. Schultz.
No, I'm just curious, like if I'm Mr. Swanson, what as the holding company that has the higher debt to equity ratio than the regulated, is the holding company itself, it's made up of multiple regulated entities, right? Does it have, like, in terms of like overall corporate structure, is there a significant amount of non-regulated entities that kind of so significantly change the capital structure? I'm just curious. I mean, like, because I'm just looking at this, and Commissioner Tuma is raising the point. It's like,
Madam Chair, Commissioner Sullivan, there still are unregulated assets of CenterPoint Energy Inc. too. I don't know, as I'm sitting here, and I'm not sure that we have someone who could tell you what percentage that is. It certainly the majority of CenterPoint Energy Inc.'s holdings are regulated.
Yeah. That's a good point, Commissioner Sullivan. That's what got me wound up back in 2015, because Mr. Campbell pointed out that if you were to take the holding company and apply its equity to make sure that it's 50-50 for CenterPoint Minnesota, that would have been like 94% or 92%, I think. I'm trying to remember the number of its equity. It was quite a bit. Now, those are back of the envelope numbers. Our staff has even looked at your tax filings and said, well, there's different ways you can measure the equity. I mean, it's a benchmark. It's not a pure science. But the point being is that if you're going to start divvying up your equity amongst all your regulated entities fairly, if that's what we would ask you to do, which we didn't back in 2003, it would be a different number that we would be dealing with at this stage. And so there's a little fiction here, but you've been stable, okay, and you've been going in the right direction. That's the part that the trend is what I really point to. You're stable and going in the right direction. Back when you were trying to be this big acquisition king back in the 1990s, you learned your lesson. It's just this. I'm just seeing the trend going the other way, trying to make sure we get assurances that no, our goal is not to become, some crazy market players or anything. We're going to be stable. We're running a utility. That's what we're selling to our investors, and that's what I think I see. But there was some concern.
And Madam Chair, Commissioner Tuma, I think that's been the consistent message from the company as well in investor calls and other forums.
And to Mr. Schultz, I mean, the OAG's office has been the leader out front over the bunker first to fight on this issue. It was your advice that led us to the 50-50 back in 2015, not your specific, because you were still here, I think, at that time, but it was OAG's office. So I hope you're still committed to watching this and understand the concern we have at the commission back in 2013, and you've been able to carry through, that you're going to be watching to make sure this company is staying solid with regards to, so they don't have too much debt versus equity. Is that the case?
Madam Chair, Commissioner Tuma, thank you for that question. Yeah, we're definitely keeping an eye on capital structure and with other utilities as well as CenterPoint, and we will continue to do so going forward.
Good, and so I think going into this is a conversation I had earlier with Commissioner Partridge about one of the things we can do at this stage is ask them to give us information. And so if you could, she was supposed to have gotten it from staff. I don't know. Ashley, did you send it to her? I think Mary was supposed to send it, but that's okay if you don't have it. We'll get it up. It's electronic someplace. And by the way, thank you for getting this up so fast, Paula. That was good work. Yeah, basically just says when you start the next rate case, give us a description of what's happening with your capital structure. I'm hoping for a better story at that stage.
Madam Chair, Commissioner Tuma, no concerns with this. As I mentioned before, we always in Schedule D at least provide this information for the most recent fiscal year as well as for the test year and any plan years. As I read this, you're just asking for us to not only do the most recent fiscal year, but the two prior, and then explain why it's reasonable to use CenterPoint Energy Minnesota Gas proposal, and that's entirely reasonable. We can do that.
To the OAG, I don't know if this I'm dreaming up at night, so and I'm not an economist or an ROE expert. I'm just trying to figure out, but I just remember this being a concern over the years. Does it cover enough for you, or is to at least get us started in the discussion in the next rate case?
Madam Chair, Commissioner Tuma, yeah, I think this is a good starting point, and we'll bring attention to the issue in the next rate case, and we can go from there.
Thank you, Madam Chair. I'm ready to move on to the good news, if you're okay with that. So, on the refund of the interim rates, I had to go back and remind myself of this because I had to go suffer through watching my stupid questions back in December. And you guys came up with a very elegant solution that I really appreciate. Commissioner Sullivan adopted it as a decision option to get the refund done, before we actually got to here, which was, I mean, I remember when watching it, you said this is kind of historic because this is the first multi-year rate case that actually settled all party. And then you pointed out it's also the first rate case that, a multi-year rate case that settled before the second interim rate increase. And then, historically, you've agreed to refund the money to the ratepayers during the heating season. All good. Yeah, you guys did a great job. All the team came up with that solution. I was just sitting here asking dumb questions, and you guys figured it out and came up with a solution. So obviously, I wanted to track that going forward. And when I got to your filings, so you filed in January 21. Here's our plan. The department came back on February 6th and said, plan's good, refund in March. People got their money back in March. And then there was a filing that was done on April 10th following the March refund. And you had some numbers, and you indicated that there was something with the January billing, and so therefore the refund was more. And then you cited a rule that I had to go look for, because it was actually not the one that you cited. It was 4,000, not 40. And so I wandered around the lost in the rules for a while, but I found that. And I was reading it, and what created me confusion, you're going to follow the rules, which is good. I got that. That's basically what the second, basically the first paragraph after the table on your April 10th says. We follow in the rules. We might have to eat a few of the bills that are less than $10. Okay, not a big deal. There's not going to be a lot. Okay, and what I was not clear on, and this is what I was trying with my decision option that I late filed. The top option, okay, basically says we don't know what the exact computations are, but file the last computations with your compliance filing in 30 days, and normally there is a negative checkoff, and it's all good. The lower one basically says, nope, April 10 has everything we need, okay? We're all in, we're all done, don't need to file anything more. That's basically what I was trying to say with these two different alternatives. I just wasn't clear whether we are all in, all done, and don't need to file anymore. So my question to the company is, are we still needing one more filing, or are we all in, all done?
Madam Chair, Commissioner Tuma, I think we need to take option A, the one more filing, the final revised computation of the interim rate refund.
And then to the department, okay, do you agree with that? You seem to be very comfortable with what everything was filed, but you haven't responded to the April 10th filing. And obviously there will be a compliance filing following. So my question, are you comfortable with that strategy? I'm comfortable with just saying, file the last thing. I don't need to come back and approve interim rates. It's already essentially done. We just need the final computations. You're comfortable with that?
We are. Thank you.
Excellent. That's the good news. And again, thank you for that. I mean, when you look back at this and see how it played out, I appreciate the company's willingness to work through this and the parties. And Cub, I think you had started that by offering a decision option the day of the hearing, so you had got us pointed in the right direction. And Commissioner Sullivan pulled me out of my confusion as I wandered through the woods and had a good motion. So I think we're all copacetic. So when you make your motion, it would be.
That's what I was just gonna ask. So it'd be just the Tuma 907. Oh, no, that one, 903, but not.
Not the lower.
But not 907, the second one? Okay.
It sounds like we're getting close to, you're ready, you both over here feel ready for deliberations. Do we have any other questions or topics that you wanted to?
Good to go.
And tell me again, Mr. Swanson, the timing of the new rates will be what? And when will people start calling the commission to thank us for approving the settlement.
Madam Chair, Commissioners, hopefully you don't get any calls from folks because the final rates will be essentially what the 2025 interim rates are. There will be a few differences, but we're thinking probably September for implementation.
So there'll be a compliance filing after the
There will.
order goes out, and then that will likely take effect in September.
That's our best guess right now, yes.
And these rates, or then, okay, then any other questions we need to know about the implementation, commissioners? Or other questions? Commissioner Sullivan, are you ready to make a motion?
I am, but I'm just waiting to see what Commissioner Partridge developed on the peak time.
Sure. Ms. Kellert, can you pull that up? I have a draft and am very much open to amendments if folks want different information included.
Madam Chair, Commissioner Partridge, the company is comfortable with that.
In the next rate case, in what decade will that be, Mr. Swanson?
Madam Chair, no comment.
And Mr. Swanson, just to clarify that I didn't put specifically, but you know that I'm talking about the E3 models. Perfect.
Yes, Madam Chair, Commissioner, thank you. And one other, I want to make sure that Commissioner Tuma's 907 isn't forgotten.
Right.
The company is comfortable with that, as well as the revised 903 from Commissioner Tuma and then the new Partridge.
I just had a follow-up question on the last sentence. Would you be comfortable with, or do you want, maybe we could have a discussion around where it says fully recovered under declining sales associated with customer electrification? I would just propose that we would say something like, to ensure utility system costs can be fully recovered due to customer electrification. And the reason I said under declining, to remove under declining sales, is that I feel like that's open to interpretation. Is that system sales? Is that?
Sure.
Yeah. Do you know what I'm getting at?
That's fine. Yeah.
I just don't want it to be the trigger, like, oh, we're not having declining sales, therefore we don't want to do this, or we don't think you need to do it. So, okay.
We could just put the E3 slides into the order.
C, E3.
Call Jared Landsman to ask about these ideas.
C, E3 presentation, May 27th, 2025.
Yeah.
Okay. So that would be, I would assume decision option, would that be a new 908 after Commissioner Tuma's 907?
Yeah, and I think, Ms. Keller, I think we can just cross out associated with customer electrification, and we can just end it due to customer electrification. Is that correct?
Yeah.
Okay. Great.
I mean, maybe I should ask the company if they're
Madam Chair, Commissioners, that makes sense, yes.
do. Are you guys cool with that too?
Chair Steven, Commissioner Sullivan, I think that's fine for the department. I think I think the important point is that you're sort of directionally clarifying that this is something to develop in the next rate case, and, you know, to the extent we need more information, we can use discovery to obtain that from the company.
Thank you.
And does anyone defect from the settlement with the reporting requirement on this? I'm looking at you.
We don't need to ask that. We don't want to know the answer.
Stay on the ship.
The old political answers, we don't need to.
All on board, Madam Chair, Commissioners.
We're good.
We're good.
We got the votes.
So
I'm ready to go whenever you are.
could you repeat your motion, Commissioner Sullivan?
So my motion is to do decision option 1. I will move to adopt the settlement and all parts. And then I'm moving decision option 901. Commissioner Tuma's revised decision option 903 in the handout. Decision option,
903 has multiple parts.
oh, all of 903.
So 903 and then Tuma's revised E.
And Tuma's revised, okay, yes, thank you.
Wait, 903A through D, and then Tuma's new revised E.
The way I said it was in the alternative, and that's, we wanted, let me just go to it so I'm saying it exactly right. I was just doing it for my notes, not, you know, it's dangerous. Decision option, so I move decision option 1 to adopt the settlement. Then, under compliance items, I move decision option 903, all parts, A through E. But I will do Commissioner Tuma's decision option, Tuma revised E, 903E. That's 903. Oh, and I do need to do decision option 901, thank you. And then I'm going to move decision option 904. Decision option 905. I will be moving Commissioner Tuma's new decision option 907 to order CenterPoint Energy in its future rate cases to disclose around the capital structure. And then lastly, I will be moving Commissioner Partridge's decision option 908 around the peak time analysis. So that's my motion. Sorry, I was a little clunky. But I support it too.
Any
I
other
think it's a good
discussion?
motion.
We know. Any other discussion on Commissioner Sullivan's motion? Hearing none, all in favor, please say aye.
Aye.
Opposed? Motion prevails.
I just want to take a moment to air grievances at Charles. Charles. I actually don't have a grievance. I just wanted to say I appreciate all the work you've done here. Thanks, Charles.
Best of luck. Good job, guys.
Yes. With that, there's no other business before the commission today. We are adjourned.
Thank you, Commissioners.
Thank you, everyone, for your work on this.